including whether you can be served in the presence of the House, whether you can be arrested in the presence of the House, whether proceedings can be brought against you for words spoken or written in a report of a parliament or committee. Allow me to come to something that is important because we may miss it. There are limits to these powers, privileges, and immunities. Why are there limits to it? One is Article 2 of the Constitution. It says, anything in contravention of this Constitution is null and void. So that if you do something that is unconstitutional, then that is null. That is not part of what the enabling law seeks to protect. And I'll share with you just one case that has been determined by our Court of Appeal now. And the Court of Appeal determined this case some time back. The case of Eric Gorsungu versus George Odinga Oraro, senior counsel. You may know him. And many of you remember that there is a death that we are yet to resolve in this country, the death of the late Robert Ouko. Many of you remember there have been various attempts at investigations and inquiries into that death. Many of you remember that Parliament in the year 2003 or 2004 set up a committee to investigate the death of that citizen, and the chair of that committee was a man called Eric Gorsungu. Something interesting happened. Of course, he was chair of a committee, so he's chairing parliamentary committee. He's in parliamentary business. He's entitled to the privileges and the immunities of the House. Then, in the course of the proceedings of that committee, my very good friend, senior counsel George Oraro, was adversely mentioned. And he got his lawyers to write to the committee and say, I now want to appear before the committee and also have my version of the story heard. That committee was meeting somewhere. I'm not certain whether it was Naivasha. I'll cross-check that fact. On a Saturday, the chair of the committee came to Parliament buildings, called the press, and gave a press statement. The press statement read, I can assure you that we are getting to the bottom of this matter, and hence the hula baloo we are hearing outside there. That is why there's a lot of hassle, because they know we are going to find the truth, and the truth we shall find. I do not want to say anything more, but I have evidence, eyewitnesses. There is a concerted effort by people within and outside Parliament, particularly those that have been mentioned, to put some spanner in the works so that this thing cannot go on. And I can assure you, we are not going to stop. We'll go on, and nobody is going to dictate to us in which manner we are going to call witnesses. I can assure them they will be accorded the chance, the opportunity to say what they want to say, and we shall crucify them. So this is the statement that the chair of the committee made in the presence of Parliament on a Saturday alone, having left his committee somewhere else. George Oraro, who was the one to whom the statement referred to, filed a defamation case. And the issue arose as to whether this conduct on the chair was protected by parliamentary privileges and immunities. The High Court found it was not, and slapped Eric Gorsungu with a bill of 3 million shillings, general damages. Gorsungu appealed. Oraro cross-appealed, saying, in fact, this award is too little. He should pay more. It is true, the Court of Appeal agreed with George Oraro and enhanced the damages to approximately 9 million shillings. I'm giving this case so that what I'm speaking here does not come across as abstract. It is real, that we need to reflect on the scope of powers, privileges, and immunities, and to act in accordance with the scope of powers, privileges, and immunities. I say this because of a number of questions that I want to ask without proffering answers. First, I know that the nature of political processes is that they can raise tensions quite a bit. And we see it both in parliament and outside parliament. That's the nature of politics. The nature of political processes is they raise tensions. They raise temperatures sometimes. But that does not suspend Article 73 of the Constitution that decrees that the manner in which you use your office must bring honor to that office. Allow me not to use the National Assembly or the Senate, but use the example of a county assembly of my home county of Kakamega, where members of the county assembly want to remove the speaker. And sometimes they get very frustrated. I don't know why. I keep asking them, but you have the power to remove him. Just go and vote. Even vote quietly. He will leave. Once the vote has gone, when I train judges or magistrates, I keep reminding them that, no, you have power in your pen, isn't it? So don't shout at me. Just write down. Just write down Ongoya is now imprisoned for 3 years. I have to go to jail. You don't need to shout at it at all. So they were so frustrated by the speaker, they decided to remove him in office quite literally. You know, removal became quite literal. So you go to the office and carry him out. Removal. The word was understood quite literally. And of course, the speaker closes himself inside the office, and they take machetes and break the office. There's a book I used to read called The Government Inspector by Nikolai Gogol. There was a teacher called the history teacher who taught his students Napoleonic Wars. And the only way he taught them how Napoleon used to fight was by picking classrooms and chairs and throwing them at the students to teach them how Napoleon used to fight. So people keep wondering, but no, those chairs are government property. You are breaking them. That door you are breaking is government property. How immune are you from the law on malicious damage to property, where you are captured actually breaking doors and so forth? I don't know whether it happens nowadays, but I think it was in the 7th or the 8th Parliament, Honorable Wetangula would remind us this, when the struggle for the mess was always real. People would run for the mess itself. I don't know what material makes that mess, but I suspect it's of value. If you broke it, I don't know whether you will enjoy privileges against a criminal charge of malicious damage to property. And another thing that I must mention as I talk about this is wealth declarations. Wealth declarations. The law requires all public officers to declare their wealth to certain responsible commissions. I trust we know that. We are the lawmakers, not get into the details of that. And it requires us to make an inception declaration. I am sure you have already declared, or if not, the clerk and her staff would guide you in making the inception declaration. When you come in, you must declare what you have, because that becomes the checklist of what you have assembled as you go out, and responsible institutions may ask, in appropriate cases, ni mvua gani ilikunyeshea in the last 5 years. It also requires you to declare that wealth at intervals of 2 years. And as you exit, to also make an exit declaration. Now, failure to comply is an offense. Failure to comply is an offense. And I know that the people who actually do the coordination and the receiving of these documents and perhaps following up on you are parliamentary staff. And there is something about when you are an officer in a department dealing with the senior most, the board, so to speak, there's a way in which the respect borders on fear. So they may not push you so hard to do it. But the question that arises is whether your privilege goes to that extent. I want to say that it is always good to live a secure life because of the transcendent nature of power. That no one may do something about it when you are still wielding power and you have some use, but somebody may take some action against you when the power is gone, and therefore it's only fair that you confirm that you have complied. The point I'm emphasizing in all these words, ladies and gentlemen, is that we have power, we have privileges, we have immunities. But that power is not absolute. Those privileges, although sometimes regarded as absolute, they are only absolute in particular parameters. Once you go outside those parameters, you may find the law visiting you for that purpose, and you may find it difficult to unwriggle yourself out of it. The other option is you may only wriggle yourself out of it with the help of a lawyer, and that is sometimes extreme cost. I say so because I'm one. Let me close by just reflecting briefly on the two critical offices that I was told to make mention of: the office of the leader of majority party and the office of the leader of minority party in the National Assembly. In reference to the National Assembly, these offices are expressly referred to in the Constitution, and therefore they are important offices to that extent. Now, it's important to understand the structure of our Constitution at the moment. Our Constitution created a significantly presidential system of government. When that happens, it means that you vest power in the executive and create institutions of check. Immediately that happens. So you have the executive sitting outside there, but you create parliament as a check to that institution. So this constitution created two offices, the leader of majority party and the leader of minority party, to substitute the offices of what used to be the leader of government business in the House and what used to be the leader of the official opposition in the House. These offices are important because, as I would say, number one, they are mandatory members of certain committees of the House. When you go through the committee works, I'm certain that you'll get over that. If you get, and I don't want to get into the current politics about which party is the majority party and the minority party, that the speaker will deal with. You have very privileged to have the speaker that you have today, because not only is he learning decision making from the House, he served as a magistrate. So he has already been inducted into decision making by the highest decision making institution in the country, the judiciary. The judiciary only makes decisions, and he has served there. I'm certain he is well equipped to deal with that. So the leader of the majority party, therefore, effectively becomes the leader of government business in the House. He brings the government agenda in the House, where the majority party is the party that forms the national executive. He therefore marshals legislative programs of government in the House, schedules legislation for floor consideration, and helps do daily, weekly, and annual legislative agenda for the executive if he comes from the party that also was privileged to constitute the executive arm of government, including marshalling the House to approve nominees to certain state offices in the executive. There are certain offices that you must approve before people take them up in the executive. He must work closely with the speaker and the party whips and consult you members and other party leaders to build consensus. I'm told diplomacy is important to get any agenda moved through the House, and that is important. He's a member of the House Business Committee, as I've said, and the Committee on Selection. He's also a member of the Committee on Appointments. Allow me just to close by looking at the leader of minority. It's also an important office. Remember, I've said it is a constitutional office. You'll find it in the Constitution first, before it's referred to in the standing orders. And among other things, he champions the minority position on issues and debates. He negotiates with the majority party, and again, I've said this. At the heart of all this is diplomacy, is negotiating, making compromises where necessary, and pushing your agenda, sometimes painstakingly, sometimes incrementally, but nevertheless making progress. He mobilizes the minority party to exercise checks and balances on the government in cases where the majority party is the party forming the national executive and where it appears to play ball quite a bit with the executive, and also marshals the legislative programs and agenda of the national executive in the House, where the minority party then becomes the party that is forming the executive. These people cannot work in isolation. They work in tandem with other important offices in Parliament, the office of the Speaker being the head of the institution, and the whips being other critical role players in the House. Allow me to close, as I began, by reminding us that we have begun an important journey. We have begun a journey. You know, changing a society's destiny is not easy. All of us in our own small way do our own little things, whether you are a nursery school teacher, to change society's destiny. But sometimes fate and nature conspire and they put you in a vantage position. Now, Martin Luther King Jr. used to say that the arc of justice always, the arc of history always bends towards justice. The problem is, very few of us have a chance to stretch our hands high enough to reach that arc of history. Very few of us. You are among those who are privileged to have stretched your hands, and your hands have reached that arc of history. Let us collectively try to push that arc further towards justice. And may God bless you, and may God bless the Republic.
Thank you very much, Dr. Ongoya, for that wonderful presentation. I think some people are worried that we've taken a little more time on that, but it was a very important session. Our next session is very brief. I think what we can say, what we can take from Dr. Ongoya is that all of you honorable members have the power to speak, and that power to speak can change the lives and destinies of the people that we represent. That you can make a minimum effort in the House by speaking, but you will have a maximum impact on the people that you represent. Now, allow me, honorable members, to present His Lordship Justice Daniel Musinga, who is representing Lady Justice Martha Koome, Chief Justice of the Republic of Kenya, and President of the Supreme Court of Kenya. His topic will be on interlinkages and interdependence between Parliament and the judiciary. Allow me also, Honorable Speaker, to briefly give the bio of His Lordship Justice Daniel Musinga. His Lordship attended University of Nairobi in 1984 to 1987. After law school, he took up a job in a leading law firm as a legal assistant in Mombasa. And in 1999, he opened his own law firm, Musinga and Company Advocates. In recognition of his successful practice, he was elected the chairman of the Mombasa Law Society of Kenya and was re-elected again in the year 2003. Because of his legal prowess, in September 2003, he was appointed by His Excellency, the late President Mwai Kibaki, as member of a tribunal investigating the conduct of certain suspended judges. His colorful legal practice culminated in his appointment as judge of the High Court of Kenya and was immediately posted to Nakuru. Subsequently, he served in various courts, the Kisii High Court, the Constitutional Judicial Review Division in Milimani, Nairobi, and later in the Commercial and Admiralty Division in the High Court of Nairobi. He also served, thereafter in the year 2012, he was appointed as a further promotion as a judge of the Court of Appeal and worked in Nairobi, Kisumu, Nyeri, Malindi, and Mombasa, and now Nairobi. In 2021, he was elected president of the Court of Appeal, a position previously held by Justice Ihara Kariuki, now Attorney General, also held previously, I think your immediate predecessor is His Lordship Justice William Ouko, now Judge of the Supreme Court of Kenya. His Lordship Justice Daniel Musinga has also received awards, one of them being the Law Society Distinguished Service in the Administration of Justice Award. He has also been named by the International Commission of Jurists, the Kenya chapter, as Justice of the Year. He has also served in various committees in the judiciary. And with that brief introduction, I wish to welcome His Lordship Justice Daniel Musinga. Welcome, Your Lordship.
The Honorable Moses Wetangula, Speaker of the National Assembly, Honorable Gladys Boshole, Deputy Speaker of the National Assembly, Honorable Members of the National Assembly, Acting Clerk of the National Assembly, Mrs. Sarah Kioko, distinguished guests, ladies and gentlemen, good afternoon once again. It is indeed a pleasure for me to join you this afternoon on behalf of the Chief Justice, Mother Kome, who is not able to be here for good reasons as explained to the Office of the Speaker, and who has requested me to share insights about interlinkages and the interdependence between Parliament and the judiciary. Let me start by congratulating all of you honorable members of the National Assembly for being elected or nominated as members of this august institution, which is the pivotal pillar of our representative democracy and the embodiment of people's sovereignty. As the arm of the government responsible for legislation and oversight, Parliament occupies a special place in our governance framework, and being trusted by the citizens to represent them in either house is a high calling for which you must all be proud. Allow me to convey my heartfelt congratulations to the Honorable Moses Wetangula for his election on 8th of September as the Speaker of the National Assembly. I am particularly proud today as the Honorable Speaker of the National Assembly, who served in the judiciary as a district magistrate from October 1982 at the very beginning of his legal career. It is said that the very first job you hold after college is the most important, as it shapes the rest of your career and your life. We in the judiciary are proud to have set the Honorable Speaker on a career path that has seen him rise to the leadership of one of the three core equal arms of the government. Honorable Speaker, we salute you. While we take great pride in the fact that he started his career in the judiciary, it was quite disheartening to learn from the interview the Honorable Speaker did with the Star newspaper in October 2021 that he quit the magistracy for private practice because the salary he was earning as a magistrate could not meet his growing financial obligations. Honorable Speaker, I am saddened to report here that 40 years after you had to leave the judiciary to pursue better prospects elsewhere, the judiciary is still losing some of its finest employees who seek better pastures in other institutions because we are not able to offer them competitive terms due to our budgetary challenges. Now that you experienced the working and challenges of the judiciary at such a personal level, we hope we can rely on you, Honorable Speaker, and the National Assembly under your able leadership to help in our quest for better funding that will enable us to attract and retain highly qualified Kenyans who will help us serve the people of Kenya. Let me also extend my congratulations to the Honorable Gladys Boshole on our election as the Deputy Speaker of the National Assembly. I am proud of the Honorable Deputy Speaker of the National Assembly, who also worked with the National Council for Law Reporting when it was administered under the judiciary, and later as the Chief Registrar of the Judiciary before moving to elective politics. There is no doubt that our experience as the judiciary's accounting officer and pass holder gave her unparalleled insights into our troubled budgetary position and other challenges which can be addressed by the legislature. I am glad that both leaders of the National Assembly have this history with the judiciary, and we hope we can capitalize on this relationship for the betterment of our respective institutions and the people of Kenya. Honorable Speaker, honorable members, ladies and gentlemen, turning to the subjects of this induction workshop, I was asked to speak to you on the topic of interlinkages and interdependence between Parliament and the judiciary. The appropriate starting point is to appreciate that Parliament and judiciary are two important pillars of our democratic and constitutional system. Under the Constitution, the two institutions enjoy relative autonomy and independence in their respective spheres of activity. Despite this emphasis on the separation of powers, the Constitution, in its architecture and design, demands that state institutions embrace a dynamic relationship so as to work to meet and realize the hopes and aspirations of the people. It is important to point out the reality that our two institutions can best discharge their mandates only with mutual deference for their powers and functions. Otherwise, there is every risk that they will perpetually wage war against each other, therefore negating the constitutional promise of governance as joint enterprise by the three arms of government. The pursuit of this constitutional promise of governance as a joint enterprise requires institutional committee. The ideal of institutional committee can only be practically realized if courts appreciate that the legislative domain is the terrain of the Houses of Parliament, whose members must be given the leeway to legislate. For example, in an important decision by the Supreme Court in the Justice Kariuki matter case of 2017, the court spelled out the doctrine of restraint that courts should not issue injunctions to stop ongoing legislative processes and should assume jurisdiction after the conclusion of such processes. Similarly, members of the legislature must respect the constitutional mandate of the courts, which is to ensure that all laws and conduct remain within the four corners of the constitutional legality. In saying this, we must always appreciate and bear in mind the fact that we are operating under a supreme constitution. The supremacy of the Constitution, honorable members, as articulated in Article 2 of the Constitution, means that the Constitution binds all state authority, organs, and institutions. Given that the values, principles, and rules articulated in the Constitution have normative force and enforceable by the courts, this means that where any state organ acts contrary to these norms, then courts must of necessity intervene to restore the intention of the Constitution. Our plea to the legislature is not to see such judicial intervention as power struggle between the various branches of government. Rather, judicial intervention properly understood is an attempt by the courts to redirect the various arms to proper constitutional channel for the pursuit of their goals. Put differently, to attain the goal of consolidation of democracy requires a strong parliament that discharges its representation, oversight, and law-making roles robustly. However, this does not mean that Parliament should enact abusive laws, fail to oversight the government of the day, and trample upon the rights of citizens, including the vulnerable and the marginalized groups in our society. Honorable Speaker, honorable members, ladies and gentlemen, the engagement between our two institutions should also be pursued in a context that is mindful of our constitutional history. We ought to always remember that both the legislature and the judiciary were often dismissed in the pre-2010 dispensation as insignificant actors in governance. This is because they were seen as being mere rubber stamps for the executive branch. This notion was connected with the widely prevailing perception then that although these two institutions had considerably significant powers under the repealed Constitution, in practical terms, they had abdicated on their mandate, thus did not play a decisive role in governance. We must therefore understand the significance of the coming into force of the 2010 Constitution as an inflection point in the place and role of Parliament and the judiciary in governance in Kenya. This historical context should make us appreciate that ours are still fragile institutions that need nurturing and support to discharge their functions, especially the shared oversight mandate, optimally as envisaged in the Constitution. I say this because the mandate and the power that our institutions hold is bestowed by the people of our beloved country to be exercised not for our sakes, but for the benefit of the people. This is why in the judiciary, we have shifted focus from institution building to social transformation, asking ourselves how we can turn the judiciary and access to justice into tools for achieving the social transformation that the people of Kenya enshrined in the 2010 Constitution. The 2010 Constitution marks a shift from a traditional understanding of the role of a constitution as being focused on limiting government powers to one which supports a responsive state that is geared towards enhancing public welfare and constructing a socially just society. This shift, honorable members, means that the government must change its perception and understanding of service delivery to the citizenry and to think creatively and proactively about how to deliver public services to all citizens in a manner that is coordinated, efficient, and cost-effective. Public agencies are now duty bearers who are expected to meet the needs of the citizens and ensure their well-being. It is for this reason that the Constitution under Article 48 obligates the state and not the judiciary, not just the judiciary, to ensure access to justice for all. In addition, Article 21, Sub-Article 1, imposes a duty on every state organ to realize the rights and fundamental freedoms, including the right to access justice. In delivering access to services to the Kenyan people, state institutions should conduct their relationships based on consultation and cooperation. This is the reason we in the judiciary are deeply honored to have this opportunity to engage with you, honorable members of the National Assembly, at the very beginning of the term of the 13th Parliament. We hope to establish through this conversation and continually hereafter warm relations that will help both our institutions discharge their respective mandates under the Constitution. We also hope for convergence in our thoughts and collaboration between our two institutions, both of which are agents of social transformation. Parliament through legislation and oversight, and judiciary through interpretation and application of the law. We cannot interpret laws in a manner that promotes social transformation if those laws were not designed to achieve social transformation at the point of enactment. We must therefore work together to serve our people and realize the promises of the 2010 Constitution. In this regard, allow me to commend the Speaker of the 12th Parliament, Honorable Justin Muturi, who readily acceded to our request to establish a corresponding judiciary parliament liaison offices to facilitate dialogue between our institutions. In May this year, the former Speaker appointed the Director of Legislative and Procedural Services, Mr. Samuel Njoroge, to head Parliament's liaison with the judiciary. From our end, our liaison is led by the Chief Registrar as the accounting officer, supported by the Chief of Staff in the Office of the Chief Justice, and the advisor responsible for legislative and parliamentary affairs in the Office of the Chief Registrar. The Chief Registrar and our team have the full blessings of the Chief Justice in this endeavor, and we hope the Speaker and the members of the 13th Parliament will offer this liaison office the necessary support as it works to cultivate these relations. To conclude, I thank you all for inviting me to come to speak to you today. I believe that working together and consulting regularly, we will be able to resolve any challenges that may arise along the way with respect to interinstitutional relationship. I wish you fruitful deliberations during the induction workshop and God's blessings and wisdom in your deliberations during the course of your parliamentary term. Thank you, and God bless you all.
And now, on behalf of the Speaker of the National Assembly, Honorable Moses Wetangula, and each and every one of the honorable members present, I wish to thank His Lordship Justice Daniel Musinga and Dr. Elisha Ongoya for the wonderful presentation and we have greatly appreciated your taking your time to be here today. And therefore, to move on to the next part of our session, I think in consultation with the Honorable Speaker, we have agreed that we can have a very brief plenary session, questions, some answers can be given, and also comments before we take our break for lunch. And but shortly before, after the questions, shortly before we break for lunch, I will invite Joseph Mudhami so that you can brief the members on the next steps. But meanwhile, I think we'll take questions. Is there somebody with a microphone? Questions or comments? Any questions, members? Comments? Or you just want to go for lunch? Okay. All right. I will not fault you on that. And therefore, I invite Mr. Joseph Mudhami to come and brief us on the next steps as we go for lunch. Thank you very much. And that was a wonderful session. I appreciate it.
Thank you so much, Honorable Deputy Speaker, Speaker of the National Assembly, honorable members, our distinguished guests. Thank you so much for your patience for this session. You have stood in well and, with the discipline Senior Ongoya was talking about. Allow me to make just 3 announcements as we close this session. Announcement 1, the prayer room is located at the Hotel Shopping Center, at the Hotel Shopping Village next to the Italian restaurant. Ladies' room will be number 10 and gentlemen's room is number 8. The prayer rooms are next to the Hotel Shopping Village, next to the Italian restaurant, room 10 for gentlemen and room 8 for ladies. It's on the left, just after the Nyamachoma restaurant. The second announcement is that immediately after this, we want to do a quick photo session so that we can have memories of this occasion. We request that some members exit through the rear entrance, others through the front entrance. The location is on the left of the registration area where you registered, on the way towards the main reception. You'll be guided on how to sit or stand for the photo session. Lunch will be served at the Nyamachoma restaurant. Then we'll be able to resume for the afternoon session. Thank you so much, honorable members. We request that we may be able to, we request that Honorable Speaker to lead members to the photo session so that we may have a photo of the 13th Parliament when all of us are together. Thank you so much. Honorable members, there's a request that we pray for lunch. Yes. Then after we take the photo session, we resume at 2 p.m. Thank you so much, 2 p.m. Let's pray. Those who have a non-ceremonial cape, or we may be able to get our capes on so that we can pray for lunch. Thank you. Almighty Lord, we come before your presence this afternoon, O King of Glory. We thank you for this day that you have made. We thank you for the offices of leaders and the people you have chosen to occupy those offices. We thank you even for the opportunity you have given them to serve your people, to lead them for the next 5 years. Father, we commit them unto you at this moment, King of Glory. Give them wisdom, give them direction, and even the strength to serve your people, O King of Glory. As we take this break, we want to pray for the lunch you have provided for us. We pray that you shall bless it, that we shall be able to give glory to you even as we enjoy the meal you have prepared for us. Thank you even for the morning session that has gone on smoothly, and we commit the remaining program to you, that will be able to give glory to you at the end of it all. Thank you once again, and may you be honored and glorified. In your holy name we pray and believe. Amen. Members, let's go for the photo session.
Parliament is one of the three arms of government, the others being the executive and the judiciary. Apart from her legislative role, the institution, which now comprises the National Assembly and the Senate, has an expanded oversight function on the executive. In view of Parliament's growing mandate, capacity building for the honourable members and staff of the Parliamentary Service Commission has been deemed necessary. This is how the Centre for Parliamentary Studies and Training, CPST, was born in 2008 and legalized through the Kenya Gazette in 2011.
When people come to Parliament, they realize that it's a completely different environment from what they may have been used to. Some could have been doctors, engineers, contractors, business people, professions of all manner of things, including university professors. But when they come to Parliament, they realize that their roles here and their day-to-day core functions are quite different from what they had previously been used to. And therefore they need to have that kind of in-house facility to train both staff and members.
The initial aim of the CPST was to serve an in-house objective, but with the realization of the needs at county level following the creation of devolved governments, the scope of operations was expanded to serve other stakeholders. The Centre's board through the PSC provides the policy direction, while the daily operations are overseen by the director. The board is chaired by Honourable Senator Beth Mugo, and the members are Honourable Senator Sami Leshore, Honourable Adan Kenyan, Dr. Abdullahi Ali, Dr. Lorna Mumelo, Jeremiah Nyegenye, Justin Bundi, Professor Ambassador Maria Nzomo, and Professor Nyokabi Kemau.
We have several visions of what we want to do, the board, and one of them is to purchase land so that we can build a center of excellence for empowering or for training our members, as well as county assemblies, as well as the whole region, the East African region. This will definitely reduce the cost that we face when we send our staff as well as members of our parliament to study or to learn outside.
The formation of the Parliamentary Service Commission in 1999 perhaps set the pace for the formation of other institutions, CPST being one of them.
In addition to the members of Parliament, we had a crash program to recruit staff to service the expanded membership of members and also the increased number of committees. So the CPST is one very useful organ to ensure Parliament, both members and staff, perform their duties properly by creating sufficient awareness on their mandate, functions, and responsibilities.
We run our trainings through three ways. We have what we call supply driven. So as a center, we have a calendar, and from the calendar we state what courses are available at the center, which we run here, right here in this campus. And from those county assemblies, either staff or members, but even our own staff in Parliament, our own members of Parliament can choose what course they want to come and attend, and that is supply. So you register for it and basically come and take the course. Then we also have what we call demand-driven, where the client, and mainly our client has been pretty much the county assemblies, even though even our own Parliament has also been our client. They come to us and request, can you organize for us a course on this area? And we quickly put together a course and get them here and we run a course for them. We also have a third way of training where we organize what we call partnership programs. And we then run programs that together with development partners we feel our clients need.
CPST also runs a wide range of short courses which include procurement within the legislature, handset training for staff in the legislature, training for chamber and committee clerks, report and minute writing, lawmaking and procedural matters, training for sergeant-at-arms, work plan preparation workshop for members and staff of the legislature, the Constitution, Parliament and Systems of Governance, management of committees and understanding the mandate of committees. The Centre also carries out tailor-made courses in response to specific training requests by directorates in Parliament and the county assemblies. Training has also been extended to parliamentary organizations in the Eastern Africa region and beyond. The aim is to equip the participants with the requisite skills to deliver on their mandate.
Building of capacity is a core pillar in our strategic plan. The capacity of our members of staff, the capacity of our members of parliament relates directly to the efficacy, to the efficiency with which they are able to discharge their constitutional mandate. From that perspective, the capacity building, the enhancement of the capacities of our staff and our members rank very high in our priorities and are a core cornerstone embedded in our strategic plan.
Being new to the existing governance structures, county governments need continuous grooming on parliamentary practice and procedures. The courses for the county assembly members and staff are therefore organized to address the emerging challenges in the execution of their mandates.
I remember at the formative stage when we were struggling on issues to do with understanding the mandate of the county assembly, CBST came in handy. And I would say categorically that CBST is the body that tried to put up a training or capacity building manual that was able to be rolled up in all the 47 county assemblies. We did that through clustering, and where we clustered the counties into 6. It is out of those clustering that CBST now was able to come up with a unified training manual that we were able to roll up.
All the counties are coming up with various legislations. Some of them, of course, are provided for in the Constitution and pursuant to their roles in the Constitution. 80% of the bills are submitted by the members. So for that effect, every county must have capacity in terms of the legislative drafters who are supposed to draft the bills for them. CPST is the only organization in Kenya which is tasked with training people working in legislatures. When we came in last year, the key emphasis was capacity building for members of the county assembly. And during the period of the whole of last year, there was a lot of effort from CPST whereby members were trained as members of the committees and in their roles at the legislature.
In order to ensure operational efficiency, the CPST has 2 directorates, namely Directorate of Administration and Corporate Affairs and the Directorate of Curriculum Development, Training and Research. To ensure successful delivery of the role and mandate of the Centre, the board, with the support of development partners, has put in place the strategic plan covering the period 2013 to 2017. The partners support several initiatives at the Centre.
In this regard, we implement a parliamentary strengthening program that has been providing diverse kinds of technical support to Kenya's parliament for about 14 years now. We have worked very closely with CPST, helping CPST to develop the initial products that it needed to begin its journey towards being a center of excellence for parliamentary training.
SUNY Kenya has worked very closely with CPST in developing training manuals, which will be very useful in training county assemblies.
Our idea is to support devolution in a manner that is methodical, in a manner that is high quality, and in a manner that encourages sustainability, because the materials that are produced are therefore capable of being used over time, and they're capable of being replicated, and they're capable of being reproduced even as the country continues to advance in the implementation of the Constitution.
We envision that CPST as an institution will continue growing and supporting the delivery of trainings and standardization of parliamentary work across the country, that the institution will grow to the extent of supporting East Africa as a region and Africa as a continent.
In the recent past, matters of gender equity and regard for minority and interest groups have taken center stage in the public institutions, Parliament included. International organizations like the United Nations have come out in support of training programs geared towards meeting this need.
By the time we started partnering with the Center for Parliamentary Studies, they were already working on a training curriculum that had about 17 training modules. But then when we started partnering, we realized that we needed also to work, to partner with them to be able to also to develop the curriculum to address the